enough to cover this evening, and it's really not slowing down. So the President of the United States made the decision at the beginning of his second term to issue an executive order that did not recognize those who are illegal immigrants here in the United States, or those who are visiting, if you have a kid here, from that child being granted birthright citizenship, stating that the 14th Amendment of the United States, in this particular instance, and well, realistically in every instance, the Supreme Court of the United States, the U.S. Constitution, what the actual formula for citizenship meant is that you are not subject to a bunch of foreign jurisdictions. So if you come here to the country illegally, or you are visiting from, let's say, China or Russia, and you have a child while you are here, then that child should not be an American citizen, because the 14th Amendment applying citizenship by birthright here in the United States is for those that aren't subject to foreign jurisdictions. Just like a foreign diplomat who is here on assignment who has a child would not then lose their child to becoming a citizen of the United States of America. And I told you yesterday, I said this was not going to win. This was not going to be good for the Trump administration. I said they are going to get smacked down on this. And I said it's for three reasons. Number one, this was really not the way to bring up this case. Number two, I said the Supreme Court is going to get really, really, really wishy-washy. I said you're going to have people that are going to argue, well, sometimes and sort of, but not quite. And the last thing that I made is my prediction, is that here in the Supreme Court's case, that you are going to see some very, very bizarre smacking down of the 14th Amendment that's going to cause a lot of heartache over the next couple of years. Unfortunately, I was correct, but I was wrong in one way. I thought that the majority opinion here would essentially be what only Brett Kavanaugh's opinion was. What does that mean? Well, the Supreme Court technically ruled 6-3, but that's not really quite true. The Supreme Court really ruled 5-1-3. So 5 members of the Supreme Court, Chief Justice John Roberts, Sotomayor, Kagan, Barrett, and then Jackson, voted that the executive order violated the 14th Amendment of the United States, and therefore suggested that clarified and interpreted the United States 14th Amendment to the U.S. Constitution to mean that if you are born here on the soil of the United States and you are not an ambassador from another country, those are the two rules. If you are born here, you're automatically a U.S. citizen, no ifs, ands, buts, or coconuts. You are granted U.S. citizenship. Brett Kavanaugh said, no, the current federal law doesn't agree with the executive order, but I'm going to punt the football on the 14th Amendment thing. That's what I thought the majority of the court would have taken. Instead, what happened today genuinely and fundamentally changes the structure of the United States of America. This is a major, major change to both the U.S. constitutional interpretation and what must now be done to remedy it, if anything at all, over the next couple of years. So let's dive into a couple of these things here. So first and foremost, because Trump's day one executive order barred citizenship for children born to parents who were unlawfully present or on temporary visas here in the United States, every lower court that reviewed it blocked it. Clarence Thomas, Samuel Alito, and Neil Gorsuch sided with the administration's argument that in the 14th Amendment, subject to the jurisdiction thereof, meant that if you are here visiting on vacation from Germany and you happen to have a child while you are here, then that child who is your child, you're from Germany, they're going to be a German citizen, not a citizen of the United States, because most of the rest of the free world and a lot of the not so free world just so happens to operate in exactly those frames and pieces. Now, in the meantime here, the major argument delivered, so the actual prevailing argument by Chief Justice Roberts, is just silly. It's probably one of the silliest arguments that I've seen from a Supreme Court justice since Ketanji Brown Jackson's last weird case that she made, like the last time she issued a decision or wrote a dissent. So Chief Justice John Roberts argued jus soli, essentially suggesting that the English common law meant that we really follow how the King of England viewed citizenship when we became a country. And so we're basically just following on this idea that, well, if you're here, you were born in the colonies and that made you an American. Very, very, very strange. Now, to parse some of this a lot better than I could, I thought we would bring on a legal expert whose expertise is in dealing with these kinds of situations. So it is good to have on Ron Coleman. Ron Coleman.
My expertise has nothing to do with these kind of situations.
Well, but, I mean, your expertise is that special kind of expertise. It's good to have you, by the way, my friend.
I'm an expert on having opinions. As Glenn Reynolds used to say in the blogging days, it still says it on Instapundit. Got a modem? I've got an opinion.
Well, let's dive right in here then. I know there's a lot that we could say, but I wanted to get your take on the 14th Amendment ruling of the Supreme Court. Is this like the general end-all be-all? Can you kind of break it down a little bit for us who aren't as versed in law?
Let me do everyone a huge favor and not try to break down the actual decision, because I believe that this is one of those questions that there wasn't really a good legal answer to. The words of the Constitution are not clear. The courts have been leaning in the direction that they came out today for a very long time. Mm-hmm. There is a very strong, principled objection to the way the courts had been leaning for all this time. I do think it's important for us to reject the proposition that because there's been all this time that matters. That's Sotomayor's favorite trope, this idea that everyone depended on the government screwing up. Everyone depended on the government not enforcing the law, and think of all the hearts that will break. No, I mean, going back to the King of England, the crown, there is no estoppel against the crown. Okay, you can't say, gosh, sovereign, you got our hopes up and now you've dashed our hopes. It doesn't work that way when it comes to the state. Having said, so what I'm saying on that point is, let's call the actual outcome a toss-up in terms of what's the right answer. Because I think scholarship-wise, it probably is pretty darn close to a toss-up. Next question is, what can we learn from the fact that Justice Roberts joined the left-wing justices in order to reach this opinion? We can deduce from this that he went full institutional.
Okay.
That is what he's accused of. The accusation has always been too broad. He's not a rhino. He's not a liberal. But he has this philosophy, and sometimes he lets us down with that philosophy. Keep in mind, he wrote some really, really important decisions, including some that came down in the last week and a half. He's a conservative, but here, there is definitely reason to be suspicious when you see him joining up with the caucus from The View.
But I understand what it is that you're saying regarding the opinions that have been written previously by John Roberts, and some of them are okay, and some of them are good, and some of them are very mediocre, wishy-washy. I was expecting Kavanaugh's take, which is that I'm not going to touch the 14th Amendment. I'm going to leave that to Congress. And instead, I'm going to say right now, federal law doesn't support the president's executive order, right? We've seen that. I mean, that was their tariff kind of decision. But this time, John Roberts did the kind of Amy Coney Barrett, where it seemed the rest of the liberal justices, Amy Coney Barrett, John Roberts, they really wanted to suggest that it would be so difficult on people. They had to create some fantasy land in which everyone is a citizen and there's no rules. And yeah, I mean, it's ridiculous.
And that does go back to my original point, which is that, well, not my original, maybe it was part 3 of my original 3-point point, which was that it's not cool constitutionally to say I don't want to rock the boat. I don't want to destroy Obamacare. Too many people will be heartbroken, disappointed, families reunite. That's bullshit.
Isn't it the point of being on the Supreme Court that you are willing to make insanely difficult decisions in order to uphold the U.S. Constitution and its interpretation?
So that is a philosophy that I think most of us would agree with. It is not the only philosophy. It's not the only judicial philosophy, but it is one that I think virtually everyone listening to this conversation, including the two of us having that conversation, would agree with. Let me leave it there.
So go ahead. No, sorry.
Well, no, but I think the real takeaway here is, well, there are two things that I think people have to keep in mind. This was not a decision about what the policy should be. No, I think a response from you on this might be, no, Ron, on the contrary, what they did was decide what the policy would be and then found a way to rationalize it in the decision. But substantively, the decision was, this can't be done this way, and that doesn't mean Congress can't do it another way. This doesn't mean the states can't do it another way. The problem with that, I mean, that is a good law school or even college political science answer.
Because the Supreme Court's gotten so good at giving that answer. I mean, that's like most of their answers today is, we don't really want to touch it. Congress, maybe you do and deal with it some way, maybe some way down the whatever. Right.
So the problem is we live in, I thought of this as I was firing up the Barbie here for this appearance. We live in a post-legislative time in American history.
Right.
Nothing that matters comes out of Congress. There will never be a constitutional amendment regarding anything in our lifetimes because there is no middle. And we exist in a space where if anything that is suggested by one party is automatically rejected because it was suggested by that party, which, by the way, probably would have been a good idea for a lot of the amendments that were enacted, especially in the 20th century. Here we are. It's bad news, but as my friend Joel Fisher said on X, I think he put it very well. This isn't quite the end of the world that many conservatives seem to think it is, because we're no longer hosting thousands of new baby makers in the United States every week the way we were 3 years ago.
Mm-hmm.
So, yes, birthright citizenship is a problem. It is a problem, especially retroactively. And it's let's face it, the way you read the opinion here, it's the retroactive that they're really talking about. But there certainly would be no intellectual defense for saying, well, I'm going to admit that Tony's right. We just don't want to trouble that many people. There is this sort of estoppel or this reliance issue. But going forward, we're going to do it the right way. They can't do that. But thank God, it's not going to be the same kind of strategy that it was in the previous 20 years.
I think that I'm getting a little radio notification. I'm going to have to chip away as they start to wind back from commercial. But I just want one kind of final take on your perspective on where it goes from here. And I've seen a lot of constitutional suggestions, an Article 5 convention, or a law passed by Congress. Is there anything substantive other than, I say we're in the post-legislation stage?
It's going nowhere. This is what it is. This is how it's going to have to be. It's going to have to be about enforcing the border and existing laws.
The State Department and the DOJ are it, period?
This is it. Wow. Enjoy it. Live it or live with it.
Well, you know what? I'll take it. Thanks for stopping by and giving us a couple of minutes of your perspective on this.
Pleasure.
I know you're really, really busy. I really appreciate it.
I really am. See you later, Tony.
But still, thanks very much, dude.
My pleasure.
All right. So let's tackle a couple of the actual executive order and the birthright Supreme Court case stuff here, because there really is, when you're looking at this kind of at a 30,000 foot view, there are some good things that are going to come out of this. And I'm not trying to silver lining you guys. I hate that kind of a thing. I'm not trying to tell you, well, actually, this is a blessing in disguise, because it's not. I want to give you the actual opinion of the Supreme Court. I want to give you the dissent. And then I want to tell you where it's going next, because it is, in fact, going somewhere, and it's going somewhere pretty important. So the actual opinion of the Supreme Court is that because the United States derives from some fancy King of England granting of citizenship, then that means that the 14th Amendment was created to just magically allot everyone citizenship. That's their argument. Radio crew, welcome back from your commercial break. Let's talk about the dissent. The dissent essentially comes in two 1-2 punch, one from Clarence Thomas and one from Samuel Alito. Clarence Thomas wrote a 91-page dissent, which is just, I mean, insane. It's insane. I've never heard of anything like that in a dissent from Clarence Thomas, who usually is like the gruff Midwestern dad. He says like 2 words and then that's it, he's done. Clarence Thomas essentially hops in and fires off that he basically calls Chief Justice John Roberts stupid. He calls Ketanji Brown Jackson a moron. He calls Elena Kagan illiterate by essentially citing all of the classical legal precedent in American law from different countries' laws. He quotes St. Thomas Aquinas at one point. And it all boils down to a